Okay, we are doing the case R versus Cooper 2005, and my name is Michaela.
And my name is Shae-Lyn. So on November 27th, 2003 at around 2 a.m., Constable Shediac and Constable McCormick, who are part of the Halifax Regional Police, were on patrol in their marked vehicle on Wise Road in Dartmouth. The officers noticed a Grand AM that was also on Wise Road traveling in the opposite direction, so they decided to conduct a traffic stop in order to check conformity with the Motor Vehicle Act. Constable McCormick, who was the driver of the police vehicle, made a three-point turn to follow the Grand AM and turned the police lights and siren on. They noticed that the Grand AM began to accelerate and made a hard left on Howe Street, followed by a hard left onto Windmill Road, continuing with a hard left onto Wallace Street, which was a dead-end street. On Wallace Street, both the drivers and the passenger opened the door while the vehicle was still moving at approximately 20 kilometers an hour and fled on foot to the opposite direction, leaving the vehicle on Wallace Street. Constable McCormick chased the driver and Constable Shediac chased the passenger, Mr. Cooper. The officers were both unaware of why the individuals were fleeing, and Constable Shediac made clear commands for Mr. Cooper to stop. However, Mr. Cooper did not listen. Constable Shediac proceeded to chase Mr. Cooper through multiple backyards, and he was finally able to catch him as Mr. Cooper was crouching in a corner of an apartment building's lobby.
Okay, so what led to the charge? The police originally planned to stop the vehicle to conduct a traffic stop to check compliance with the Motor Vehicles Act. After the passenger and driver both fled from the police, Constable Shediac handcuffed Mr. Cooper. Shediac walked Mr. Cooper back to the Wise Road where other police officers were. Constable Shediac originally arrested Mr. Cooper for resisting and obstruction, then performed a protective safety search for Mr. Cooper. When completing the search, he found a butterfly knife, which is prohibited under the criminal code. When Constable Shediac asked Mr. Cooper his name originally, he identified himself as William Buffett, until later finding out his real name, and William Buffett was an alias name he used on other occasions. Okay, so the charge, Mr. Cooper was then charged with A, misleading a police officer by giving a false name contrary to section 140 of the code, B, resisting an officer in the lawful execution of his duty contrary to section 129, C, possessing a weapon dangerous to the public peace contrary to section 88 of the code, D, possessing a prohibited weapon contrary to section 91 of the code, and C, possessing a prohibited weapon knowing that he did not hold a license contrary to section 92 of the code. The legal aspects. The trial proceeded before Judge Murphy of the Provincial Court. So the defense applied for a ruling that 1, Mr. Cooper was detained contrary to section 9 of the Charter, arbitrary detention. 2, the search which discovered the butterfly knife violated section 8 of the Charter, unreasonable search and seizure. And 3, the knife and subsequent misidentification statement be excluded under section 24, subsection 2. The case law raises several guiding principles governing the use of a police power to detain for investigative purposes. The evolution of the Waterfield test, along with the Simpson articulable cause requirement, calls for investigative detentions to be premised upon reasonable grounds. The detention must be viewed as reasonably necessary on an objective view of the totality of the circumstances, informing the officer's suspicion that there is a clear nexus between the individual to be detained and a recent or ongoing criminal offense. Reasonable grounds figures at the front end of such an assessment, underlying the officer's reasonable suspicion that the particular individual is implicated in the criminal activity under investigation. The overall reasonableness of the decision to detain, however, must further be assessed against all of the circumstances, most notably the extent to which the interference with individual liberty is necessary to perform the officer's duty, the liberty interfered with, and the nature and extent of the interference in order to meet the second prong of the Waterfield test. While the police have a common law duty to investigate crime, they are not empowered to undertake any and all action in the exercise of that duty. Police officers may detain an individual for investigative purposes if there are reasonable grounds to suspect, in all circumstances, that the individual is connected to a particular crime and that such a detention is necessary. In addition, where a police officer has reasonable grounds to believe that his or her safety or that of others is at risk, the officer may engage in a protective pat-down search of the detained individual. Both the detention and the pat-down search must be conducted in a reasonable manner. The question is, did the search violate Section 8 of the Charter? Mr. Cooper's conviction for possessing a weapon dangerous to the public peace is based on the seizure of the butterfly knife while he was searched shortly after his detention. A warrantless search without a valid consent is unreasonable unless justified under the test stated in R.V. Collins, 1987. A warrantless search without valid consent may be authorized at common law as incidental either to a lawful arrest or to a lawful detention. The trial judge found that the police had no reasonable ground to arrest Mr. Cooper. The issue argued in this court was whether the search was incidental to what the trial judge determined.
So under the first prong of the test, the front end determination is as of the moment of detention. Information that was later acquired, such as the knowledge that Mr. Cooper possessed a prohibited weapon, is trivial. Whether a police officer detained on reasonable grounds or just a hunch is assessed based on the information known to the officer when he detained the individual. The second prong being Waterfield, which has already been discussed. After viewing these, it was put into consideration whether the trial judge properly applied those principles to Mr. Cooper's circumstances. The trial judge found that the police officer's intent was to conduct a traffic stop, which was supported by Constable Shediak's testimony. Reviewing this, the trial judge committed no error that would require a reevaluation with that finding. The trial judge then noted that the occupants of the vehicle were young, operating a vehicle after midnight curfew for new drivers, and concluded that the officers were within their rights to conduct a traffic stop. Newly licensed driver 70A. A person issued a driver's license as a newly licensed driver in accordance with subsection 1 may drive a motor vehicle upon the highway subject to the following conditions. C, between midnight and 5 o'clock in the morning, only when accompanied by a person who is an experienced driver, holds a valid driver's license of a class 1, 2, 3, 4, or 5, as set out in regulations made pursuant to section 66, and the driver's license class is the required class for the vehicle being operated and is seated in the front seating position. It is important to note that the police officers did not require objective justification to conduct a traffic stop. A legitimate traffic stop, which is authorized by law to check matters such as sobriety, licensing, which includes curfew, conditions of license, ownership, insurance, and mechanical fitness of the vehicle, though it may be arbitrary, is justified under Section 1 of the Charter. A detention, however, loses the justification if the police conduct exceeds these traffic stop objectives to become a pretext for criminal investigation. In Nova Scotia, traffic stops are authorized by statute, and the police power focuses primarily on Section 83(1) of the Vehicle Act. In this case, the offense activated their police lights and siren to signal the Grand AM to stop. Instead of stopping, the Grand AM accelerated and made hard rolling turns in what the trial judge found as what was an attempt to evade the traffic stop. Constable Shediak testified that his chase and eventual detention of Mr. Cooper were the result of the resistance to the attempted traffic stop. The behavior of the Grand AM gave the officers a reasonable basis to conclude that there had been an offense of resisting a traffic stop. This would be an offense under Section 83(1) of the Motor Vehicle Act. The officers, in attempting the traffic stop, were committed to the execution of their duty under the Motor Vehicle Act. The resistance to the signaled traffic stop justified their conclusion that there has been an offense of resisting a peace officer in the execution of their duty opposed to Section 129, subsection A of the Code. Judge Murphy acquitted Mr. Cooper of the charge under Section 129A. The issue was argued on that the appeal was whether there was a lawful detention under Section 9 of the Charter. It was suggested that the evasion of the signal traffic stop gave the officers a reasonable basis under the front-end analysis and standard required for detention to suspect that an offense of resisting a signaled traffic stop had occurred either under Section 83, subsection 1 of the Motor Vehicle Act or under Section 129A of the Code. The next thing that was questioned was if there was a clear connection between Mr. Cooper and the suspected offenses. Mr. Cooper's counsel brought up the issue that only the driver of the vehicle is implicated in the resistance to the traffic stop and that Mr. Cooper, a passenger, necessarily is unconnected to such a driving offense. This is determined by the information that is accessible to the police officer at the time of the detention. The detention occurs when the police officer stops the individual in a manner that involves significant physical or psychological restraint. This occurred when Constable Shediak apprehended Mr. Cooper in the lobby of the apartment building after the chase. Whether there was reasonable grounds for the detention depends on the information known to Constable Shediak at the moment. This includes the facts related to the flight after the signaled traffic stop. It is not limited, as suggested by Mr. Cooper's counsel, only to the facts known to the officers when they initiated the attempted traffic stop on Weiss Road. The standard of reasonableness for detention differs from the standard for an arrest under Section 495, subsection 1 of the Code. For detention, it is sufficient if there is a clear nexus or connection between the individual and the recent or current offense, or that the individual is implicated in the criminal activity. The nexus, connection, or implication acknowledges that at this investigative stage, there may be a margin spanned by the connection between the individuals and commission of the offense. The trial judge found that while the Grand AM was traveling at 20 kilometers per hour, Mr. Cooper opened the passenger door, bailed out, and ran away through the backyards to escape the police. Mr. Cooper's behavior gave the police an objective basis to suspect that Mr. Cooper was connected or implicated in what the police reasonably believed to be an offense of resisting a signaled traffic stop. During the curfew check on a traffic stop, the officer would be entitled to inquire whether the passenger satisfied the conditions of Section 70A 5C, which was quoted earlier. After Mr. Cooper took flight, Constable Shediak instructed Mr. Cooper to stop. Mr. Cooper did not, so Section 83, subsection 1 of the Motor Vehicle Act states that it is an offense for any person to fail to comply with an order of a peace officer respecting a traffic stop. This differs from Section 83, subsection 2, which states that it is an offense for the driver of any vehicle to disobey traffic signs. Constable Shediak had reasonable ground to suspect that there was a clear nexus or connection between Mr. Cooper and a recent or ongoing offense under Section 83, subsection 1 of the Motor Vehicle Act or Section 129A of the Code.
Okay, so grounds to detain. Counsel for Mr. Cooper submits that to infer grounds for detention only from the individual's choice not to cooperate with police contravenes the individual's fundamental rights of silence and to decline self-incrimination. This statement was in disagreement for the following reasons. In a case from the American Fourth Amendment in the Stop and Frisk Doctrine in Terry v. Ohio, 1968, the Chief Justice stated that in reviewing the property of an officer's conduct, courts do not have available empirical studies dealing with the inferences drawn from suspicious behavior, and we cannot reasonably demand scientific certainty from judges or law enforcement officers where none exists. Thus, the determination of reasonable suspicion must be based on common sense judgments and inferences about human behavior. Therefore, when an officer without reasonable suspicion or probable cause approaches an individual, the individual has a right to ignore the police and go about his business. To this, Mr. Cooper did not merely choose to remain silent. He fled on an occasion where resistance to the police direction could reasonably be suspected as an offense. Mr. Cooper fled from a reasonably suspected offense, and his flight gave to the police an objective basis to suspect that he was connected to that offense. The next point is that investigative detention does not impose an obligation on the detained individual to answer questions posed by the police. And again, the detention did not invade Mr. Cooper's rights to silence and to resist self-incrimination. Now looking at the other side of a reasonable grounds, the Crown submits that the police have a duty to prevent crime and therefore was entitled to detain Mr. Cooper if the police had a reasonable basis to believe that Mr. Cooper might commit a crime in the future. Mr. Cooper's detention was based upon Chediak's reasonable basis for suspecting a clear nexus or connection between Mr. Cooper and a recent or ongoing offense, namely failure to comply with a signaled traffic stop under Section 83, subsection 1, and resisting an officer in the execution of his duty to direct such a traffic stop under Section 129A. The trial judge concluded that when Chediak took up the chase and then detained Mr. Cooper, the officer was acting in the course of his duty. His duties at common law included the preservation of the peace, the preservation of crime, and the protection of life and property. So to conclude this, therefore, the trial judge concluded that the detention was proportionate to the requirements of Chediak's police duties. The trial judge committed no reviewable error in her conclusion that Mr. Cooper's detention did not violate Section 9 of the Charter. The butterfly knife was seized after a detention and search which complied with subsection 8 and 9 of the Charter. There is no basis for excluding admission of the knife under Section 24, subsection 2. After locating the knife, the officer asked Mr. Cooper his identity. Mr. Cooper gave a false identity, which led to the conviction of public mischief for misleading an officer. As there was no violation of Mr. Cooper's constitutional rights under Section 8 or 9, before he gave the false information, no issue arises respecting the exclusion of that evidence under Section 24, subsection 2 of the Charter. The appeal was dismissed. Judge Murphy convicted Mr. Cooper of possessing a weapon dangerous to the public peace, contrary to Section 88 of the Code, and stated the other two weapons charges under the Kennepel principle. Judge Murphy acquitted Mr. Cooper of resisting under Section 129A and convicted Mr. Cooper of public mischief by misleading an officer under Section 140, subsection 1B of the Code. And that is the end of our presentation. Thanks for listening.